Yeah, we live. Okay. Good morning. Today's March 31, 2025. It's 9:31 a.m. We are here at the table of the District 4 Environmental Commission, a meeting in Bolton, Vermont to conduct a hearing on application number 4C0436-40, filed by VVR LLC and Picnic Loop LLC for the creation of a 5-lot subdivision on a 731-acre tract of land and the creation of a total of 48 residential dwelling units. A summary of that, the project is this. Lot 1 is proposed for 12.34 acres and 5 buildings with a total of 32 units. 3 townhouse-style buildings and 2 multi-family-style buildings and associated infrastructure. Lot 2, 1.05 acres with 1 multi-family residential building and 16 residential dwelling units, accessed from a private driveway off of the Bolton Access Road. Lot 3, 6.49 acres of conservation lot where the existing Nordic trails will be abandoned and wetland mitigation activities will be applied. Development would be prohibited on Lot 3. Lot 4.82 acres is the private road accessing the residential dwelling units on Lot 1. And then Lot 5 is everything else, 710.3 acres, the remaining portion of the parent lot. No development is authorized on Lot 5 at this time. The permit would specifically authorize the construction of the residential dwelling units and infrastructure on lots 1, 2, and 4. Development is prohibited on Lot 3 and Lot 5. Lot 3 will be conserved. Proposed future development on Lot 5 will require a permit amendment. The project is located at 3969 Bolton Valley Access Road in Bolton. My name is Tom Little. I'm the chair of the District 4 Commission. I live in Shelburne, and I'll let my fellow commission members introduce themselves.
Monique Gilbert.
Pam Loringer, Colchester.
I'm sorry.
And Caitlin Hayes, to my far left, is the District 4 coordinator for this project. And we also have a backup for Stephanie Monahan, who's also from the commission staff. So I have to recite some provisions of Vermont's amended open meeting law and confirm that we have taken the following steps. We are providing public access to the meeting by online video conference with additional access offered through telephone. We are using the Microsoft Teams platform for this hybrid meeting. All members of the commission have the ability to communicate contemporaneously during this meeting, and the public has access to contemporaneously listen and, if desired, participate in the meeting by attending in person, downloading the Microsoft Teams application, or by calling into the toll-free number provided in the meeting notice. In addition, we provided public notice of instructions for accessing the meeting. We previously gave notice to the public of the necessary information for accessing the meeting, including how to access the meeting using telephone or Microsoft Teams in the meeting notice. That document, including those instructions, have also been provided in the meeting notice on the Act 250 database online. We've provided a mechanism for the public to alert us during the meeting if there are problems with access. If anyone has a problem, please call the following number, which was provided in the meeting notice. That's 802-828-7667. Conference ID number is 794754523. Hashtag. As you figured out by now, the meeting is subject to Vermont's open meeting laws. By participating, you are consenting to being audio/visually recorded, and for that recording to be published in the commission's online database and YouTube channel. Any written information or exhibits provided to us or the Act 250 staff regarding the permit application, which is official state business, are considered public records and will become part of a permanent record to be published in the Land Use Review Board's online database. The chat function has been disabled for this team meeting. The hearing is being recorded, including any noises, barking dogs, personal conversations made when your microphone is not muted. Therefore, please mute your microphone when not speaking. Do we have anyone so far?
Not yet, and I do just want to know, I'm not sure if it's on here, this microphone is very sensitive, so any other side conversations will probably be caught on the captured, I should say, on the audio.
For anyone who is participating remotely, if you'd like to speak during the hearing, please raise your hand if you're in the hearing room. If you're participating online via Teams, use the raise hand feature located in the toolbar in the top center of the screen. If you're participating by phone, press *5 to virtually raise your hand and *6 to unmute and speak up so that we can hear you. For the audiovisual record and for the benefit of those participating solely by telephone, please state your name before speaking, and if relevant, your street address. Finally, and this is important, please do not log into the Microsoft Teams meeting on a computer or other device and participate on your phone at the same time, because that will cause some very distracting audio feedback that can greatly disrupt the hearing. We have a sign-in sheet that I believe everybody present in the room has signed with your name and your contact information. We will be issuing a hearing recess order after we conclude the hearing within a couple of days. That's how we will send it to you. I don't know that I'm going to do a roll call because we have that. Is there anyone who hasn't signed in yet? Okay. And Caitlin, you're not going to be able to read anybody participating by Teams because there isn't anybody, right? Conflicts of interest. The commissioners have reviewed all of the materials submitted for the application, in part with an eye towards identifying any conflicts of interest that any one of us might have. We are not aware of any conflicts of interest that need to be disclosed at this time. Does anyone here in the hearing room have any concerns about the commissioners that will be reviewing this application? Any conflicts of interest? Being none, outside of today's proceedings, I remind everyone that all communications, whether by letter, email, telephone, or in person, must flow through Caitlin Hayes, our district coordinator, and not through other parties or commission members. I'm now going to ask anyone who thinks they might address the commission during the hearing to swear or affirm that they will tell the truth. Accordingly, anyone who expects to address us, please raise your right hand. Do you solemnly swear or affirm that the testimony or evidence that you will provide relative to the consideration of this Act 250 application shall be truthful, accurate, and complete under the pains and penalties of perjury? If so, answer, I do.
I do.
In a few minutes, the applicant will give us an overview of what is being applied for. But first, I'd like to make some comments on party status and the process for participating in the hearing. And this goes into a fair amount of detail because most of the time when neighbors and other community members are present, they haven't spent a lot of time over the years going to Act 250 hearings. So let me go into the party status rules. Our responsibility is to collect evidence as to whether this project meets the requirements of Act 250, and based on that evidence, decide whether to issue a permit with or without conditions, or to deny a permit. We gather the evidence in order to make an informed decision. This hearing is part of the process to collect that evidence. You might want to participate in this proceeding as a party. Party status is outlined in the Act 250 statutes. It is important mainly for two reasons. First, a party may introduce evidence, bring in experts or other witnesses to testify and take part in the arguments. Second, only a party may appeal our decision to the environmental court if they are unhappy with our decision. Party status is decided on an issue-by-issue basis. So Act 250 is organized around 32 criteria and sub-criteria. When your term comes and you wish to address us and to seek party status, identify yourself, explain where your property is located, and identify each Act 250 criterion under which you believe the project will adversely affect you or your property. Then explain how you think the property will have specific impacts on you under those specific criteria. The commission will make party status determinations here today on a preliminary basis so that we can organize the hearing. There are times after we hear all of the testimony that we decide that while it appeared at first that someone should be given party status under a specific Act 250 criterion, ultimately they did not prove or document an impact under that criterion. So we can adjust, revise our party status determinations when we issue a final decision. And with that in mind, there are three categories through which a person may participate in the hearing. I've just given you the main one, party status. Some parties are parties by statutory right. The state of Vermont and its agencies, the town select board, planning commissioners, regional planning commissioners are parties by right. Secondly, any person may also be admitted as a party if they can show a particular interest, as I've described, that might be affected by the project and demonstrate that their interest is related to one or more of the Act 250 criteria. Those who are admitted as parties, as I've said, will have the right to appeal our decision. Even if you do not qualify as a party, the commission may allow you to participate as what we call a friend of the commission. If you are able to offer the commission certain information that might not otherwise be available to us. For example, you might be an attorney, an engineer, a scientist with specialized knowledge. Within the discretion of the commission, your participation may be limited, and friends of the commission do not have appeal rights. No one is required to seek party status or friend of the commission status. And our practice is if you don't want any of those formal statuses, but you do want to share some thoughts or concerns about the project, you can share them with us at the right time. Some neighbors simply are here to listen and become more informed about a project, and we welcome that. Does anyone have any questions at this point about the process we will be following? Still awake, good. So for the record, the commission visited the site earlier this morning where we reviewed the site plan, walked around the property, observed the wetland areas, snow covered, streams, places where streams will be crossed. So we took note of the slope of the land, the forested nature of the area, and the applicant and others pointed out certain things on the landscape to and drew our attention to them. We are now at the point where asking the applicant to present a general overview of the project in brief, keeping in mind that we have read the application and the exhibits. We've been to the site. And in doing so, the applicant will explain how the project addresses the Act 250 criteria. Particularly the criteria that there is not likely to be any concern about. Later on, we will go into more detail about waste management, streams, water supply, wildlife habitat, soil erosion, the impact of growth, private utilities, and local and regional planning. Now is the time, if someone wants to request party status, for them to be heard. And I note that we received last week a written party status request from Megan Murphy. Megan, are you? Hi. Good morning. Did you have anything you wanted to add to that? So we have that. That's the party status request for party status under criterion 4, which is soil erosion. 9A, impact of growth. 9G, private utilities, and 10, local and regional planning. Hey, can you show us on the site map where you live? You can actually help. We'll just go right up and.
This neighborhood, and I think you're like right here off of. Yeah, I'm in this section.
Okay. Okay, thank you. Anybody on the commission have any questions? Does the applicant have any questions or any comments on the party status request?
If I can comment on it or
Yep,
respond
now's
to
the
it.
time.
Yeah, I would. I guess I would just like to challenge. Oh, I'm sorry, Lindsay Deloria. I guess I would like to challenge her request for party status on the grounds that she lacks, specific or particularized interest. As you can see on the map, her property is not adjacent to the project site. As you know, she stated in her application, it's close to half a mile away from it. It's also at a significantly higher elevation than the site. May be hard to see on the map, but that's a very steep, it's the access road steep up, and then the Wentworth Road also goes up. Pretty steep, also a steep road up. So, it would be impossible for there to be any stormwater flow from the project site toward her property. On the water and sewer system, she cited 2 concerns that I saw. One was the impact to rates associated with the improvements, associated with improvements made to create capacity for this development. And then 2, that this development, kind of the same thing, that this development is the reason for planned upgrades to capacity. I think even before addressing those, which I will and want to, I would just challenge whether being a ratepayer in the community, in the community water system constitutes a unique or particular interest. But I can also just say that actually that statement is incorrect. No improvements have been made to the water or sewer system to support this development. Both have adequate existing capacity to support the development. Any costs associated with new service infrastructure to connect to this development won't have an adverse impact on current ratepayers. All of the costs will be borne by the developer or covered by grant funds. In fact, this new development will have a positive impact on the current ratepayers and on the financial position of the water company in general, because the developer will pay a hookup fee that will bring new revenue to the water company. That revenue is actually slated to offset costs associated with a separately planned improvement to the wastewater system that you've also reviewed. And it will reduce the water company's need for debt associated with that improvement. And, finally, you know, it will add to the rate base of the water company, which will help to support the ongoing debt service associated with that and just generally increase the rate base. So actually it will have a positive effect on water rates moving forward. And then just lastly, you know, I mentioned in terms of her particular interest in stormwater, obviously being at higher elevation, it couldn't have a direct impact on her property. But her letter stated that we're out of compliance with our permits, and that's not true. We are in compliance with our permits. And last summer or fall, I believe Megan or Miss Murphy had submitted a complaint to DEC to question that. We had a site visit, compliance officer came up, Dana Nagy had a site visit, inspected the site, we're in compliance. So I just would say that
We'll take that into consideration when we make our determination. The next person on the sign-up sheet, Kim Schmidt, do you wish to seek party status? Thank you. Walter Duda,
Yes, I'd like to see party status.
could you show us where your place is?
Same street as Megan, first house above the condos. It's going to be right about, I guess that's my lot.
No, that's the condos. Your lot's where the K is.
Okay.
You're on
Yeah, my lot
okay.
is right up here.
General idea.
Okay.
There's 2 vacant lots between the condos.
And Walter, what criteria would you like to become a party on?
May I have the listed criteria so I can see? I mean, I could say the same as Megan, but I also, if I can see the list, I'll see if there's any other that could bind me to this.
It's a long list.
Well, that's okay. I'm a former state employee. I'm used to long lists.
Do you have a smartphone, Walter?
I do, but I have not integrated it to my computer because it's less secure.
Okay, I'm wondering if it might make sense for, there. Thanks, Zach.
While you're taking a look at that, Walter, I'll go on to the next person who's signed up. You guys take you.
Chair, may I make one statement?
Sure.
While increasing the customer base may decrease the cost for consumer, it's not clear to me that that's true because this is an organization that has paid staff, and maybe the pay that members are receiving is sufficient, maybe it's not. So I'd like to assume that an increased ratepayer base would decrease our cost, but I can't assert that's true. Because after all, there are people making wages off an organization that's losing money right now. So I would assume if it were my place to manage an organization like that, I would begin increasing pay rates as customer base increase. I'm saying I cannot assume that an increased customer base is going to decrease rate costs over time. Maybe if we had a highly concentrated group of people up here, eventually rates would have to go down. But while this is a nonprofit, it's under the same, it's kind of like a business. I actually worked for Capstone Community Action for several years.
So can I take that to mean that you would like to be considered for party status on criterion 9G, which is private utilities?
Yes.
Okay.
And also, we're not sure that there's sufficient water because we don't meter it. And we constantly have leaks up here that must be repaired, which reduces the amount of available water to all ratepayers. Number 5, I can go with. During the building process, we will have heavy equipment moving earth, all kinds of stuff up here. We have one way in and out of here, period. And number 8, I suspect, depending on how the building's profile, they may affect my view from the deck. Once the trees are out, it'll be less than an impact, but initially. And also number 9. And thank you.
Yeah, so that's just.
Which 9?
We talked about.
So number 8 and conforms with, I guess not number 9.
We talked about 9G, private utilities.
Oh. Yeah, 9G private utilities.
Next on the sign-up sheet is Leah Scott. Lists her status as select board member and neighbor, 223 Thatcher.
Yes,
Good morning.
good morning.
Could you show us where that is on the map?
Purish.
Okay.
I know, approximately, sorry. Okay. So I would like to be added as party as a select board member. Is that one of the choices for governance?
I think you already are.
I think, I'm not sure we've encountered this before, but I think that the select board as a select board has party status as statutory party.
Okay.
Did the select board like appoint or
No.
designate you to speak?
No,
Okay. So we could treat you as a neighbor, is that right? And which of the criteria do you wish to be heard on, based upon what you've seen so far?
I think I'll just be regular listen and commentary. I don't need to be added as party for any of those topics.
Jessica Moschella? Did I get that? Okay.
Yeah.
Good morning. You're at 138 Thatcher, which is the same place that Leah just told us about. Okay. And what would you like to be considered for party status?
No.
Okay. And Stephen Diglio.
Here.
Good morning.
Good morning.
And you're on Thatcher as well, right?
Yeah, I'm his neighbor.
And would you like to be considered as for party status?
No, thank you.
Okay. Let's break for a few minutes.
Yes, so to deliberate, I'm going to
We can just go and.
put this up and I'm going to, we're going to do a deliberative session, going to mute us and turn the video off while we're in deliberative session.
Okay. Let me know when we're back.
We are unmuted and video is back on. We're good to go.
And the commission is out of recess, back in session, and our determination, and this is typical for how we tend to make these decisions, is for the purposes of this hearing to grant on a preliminary basis the party status requests of Megan Murphy and Walter Duda, subject, of course, to their ability to present testimony that sustains that preliminary determination. So that is what we're going to do on those. And let's now have the applicant give us an overview of the project. As I said earlier, considering that all of these documents are posted publicly, we've read them and been to the site. So whoever you wants to go first, introduce yourself and proceed.
Okay, I can start. I'm Lindsay Delorde, again. And I won't go into great detail on the site because actually you sort of gave the high level detail of it in your remarks, but I'll just talk, if it's okay, a little bit just about the process, and it's been quite a journey to get to this point. You know, this site is, you know, relatively high elevation. There are a lot of natural resources up here. We knew out of the gate that it would require careful and innovative planning. It was an innovative process that we went through. So interesting, I think, that Scott Honstead, our civil engineer, used it as a case study for his keynote to the annual meeting of civil engineers. And, you know, our goal at the outset was to create more residential housing. We knew that, but we were very open-minded about what that would look like or how and where that would happen. We recognized the significant natural resource constraints, and so we started by asking a really high-level question of where new development would even be possible here in the resort village on the resort property. We invited A&R to the table at the very beginning to work with us out of the gate. This was about 4 years ago now, so it's been a long process. And they guided us through this, you know, really through this process. We started by commissioning the creation of what we call our base map by Arrowwood, who are here today, a high-level comprehensive resource map of the entire property. Once we had that, we could identify areas of opportunity, potentially feasible development sites, and then zero in on those areas for further and more detailed assessment. We worked with A&R on commissioning that project. They looked at the results, helped us to determine those potentially feasible sites, and then started out with initial site visits to assess the feasibility. Our initial concept for this development started out quite a bit larger, but like I mentioned, A&R was up, we looked at it, and very quickly we were able to rule out areas that looked good on the map, but not good in reality. And then we just focused our energy and design and attention on the locations that we agreed were truly feasible, truly suitable for development. The resort village is the primary growth area for the town of Bolton. It has a relatively dense footprint, residential footprint already. It's got the infrastructure to support it, including the water and sewer system that we talked about. And our approach is really to let the site and site constraints in particular dictate our project design, and that's what we've done. We're really pleased with the result, really pleased to present this project that we believe will be good for the community. It's environmentally responsible, helps to address our regional need for more housing, bring more prosperity to the town and the resort village, and that we think is a really good example of planning. It's planning for smart growth. We've involved the community throughout the process. We've held really well-attended community meetings to share our plans, to get feedback, to answer questions and address concerns over the past few years throughout the process. And in general, we've found that the community is supportive for the project. And I think and hope you'll hear some of that support today. This particular location was actually identified by the community through a master planning process that the town engaged and led. to look as the most promising site for new housing development in the village area. They looked at the resort village for master plan, and the community process led to this site as the most promising for new housing development. One of the key advantages is it provides easy access to connect to existing utility services. As we saw this today on our site visit, the sewer main actually runs right alongside the project. The water and electricity run right along the access road, and so offer really easy connection points, all of which have sufficient capacity to support this development. There are planned upgrades to the water system, which I talked about, and I was planning to sort of talk about how that will positively benefit the revenue of and the rate base of the water company, but I've already said it, so I won't repeat it. Interestingly, during our site visits with A&R, the A&R staff, particularly the riparian staff, pointed out that this zone was already somewhat distressed. And accordingly, our mitigation plans are really, really robust, particularly with respect to the riparian zones and the wetlands. We're going to be preserving and restoring more wetland and riparian zones than we're impacting. And while our impacts are primarily in the buffer zones, the restoration is really focused on actual streams and actual wetlands. So a positive impact, we think. We've also over-designed our stormwater treatment measures, as what Scott talked about, exceeding baseline standard requirements. That was something that came up in our DRB hearings. The DRB has given it preliminary approval. They're waiting on state permits to give final approval. Steve is actually a member of the DRB. I invited him, let him know, reinforce that this was happening. He's also, as it turns out, a civil engineer. So, and I'll just conclude by just saying, A&R staff isn't here. Maybe a testament to their support. You've gotten their letters. But it's been a really positive process. We learned a lot from our process of the mountain biking, and we're really proud of where this has landed, proud of how it's evolved, and really looking forward to making this plan a reality and to welcoming new families into our community. We appreciate your time, your consideration. You're taking the time to come up and do a visit, walk around. We're of course happy to answer any questions. I'll just turn it to Dory and Aaron from Arrowwood, or Scott, if there's anything that you want to say particular to the project. I hadn't planned to rehash it because you've seen the plans, but just wanted to talk a little bit about the process.
Okay. Well, I know that some of us were a little nervous when we got up Saturday morning about what it would be like to get up here, but that worked out. Okay.
We want to see if Scott.
You want to add anything to that as an overview?
I don't know if I need to do anything in overview. Are you gonna do like a line item of all the
We're gonna do
criteria?
that,
Yeah, I think I just wait and adjust my part and stuff.
I would say if we're doing a line on the same thing.
Okay. So one of the things that we do through the hearing process is to go specifically through the criteria that we know are of concern. And those, in this case, are some of the ones that have been identified by Ms. Murphy and Mr. Duda, but a couple of more. And we'd like to start with 1B as in Baker, waste management / 9J, public utilities. Caitlin, can you tee that up to see what we're still waiting for?
Yeah, I think it would be helpful to understand what the relationship is with this project and the upgrades to the facility. Is there any dependence on this project on those upgrades, and maybe a status update on where that project is?
Sure. There's not a direct relationship between this project and the wastewater upgrades. I would say, the biggest relationship is that the wastewater upgrade is really expensive. It's a very expensive project for this community, estimated around $8 million, which is like pretty expensive for this community. The water company has been able to, source some grant funds that we're anticipating to offset those costs, but the bulk of the cost will be through debt service. And so, the timing of this project from a financial standpoint, around the hookup fees, around the adding to the rate base, are really seen as advantageous. We had a community meeting a while ago where we laid out the projected rate increases associated with it. And, the difference in rate increases over a period of years, like, I think it was like maybe 8 years looking of annual increases to sort of build up to cover the debt service. The projected, and of course, these are subject to change, this is just a projection, but the projected difference was 3% annual increase with these new ratepayers versus 5% annual increase without these new ratepayers, so a positive effect in that sense. But in terms of like the capacity, it's not, that's not the issue. The wastewater does have existing capacity to support this development. The need for the wastewater project is really that the facility is old. It's in disrepair. It has zero redundancy. RBCs are largely going out of use anyway. And this only has one contactor that our engineers, that we've been advised can't be repaired because of the risk of being able to get it back online without any redundancy. And so, this planned upgrade for the community it's necessary. And
That's
expensive,
part
this
of your-
will just help with it. But I know that the financial piece isn't your consideration, but that's what I would say is the strongest connection between the two projects.
Okay, so are any of the utilities public, or are they all private?
The utility up here is a private utility,
Okay.
but it is a community utility
that's
because it serves over, don't ask me to remember the number, but, it meets the threshold of the community service.
I believe it's 24 or 25.
I'm not sure.
At least for water.
That answer your,
I just will say the two other, we're waiting on the issuance of the wastewater permit, and we'll need a construction site waste reduction plan and approval from A&R. There'll be a hearing recess order that's issued at the end of this that will have any lingering items from the applicant or other parties that the commission will need to see.
so, I was trying to collect my thoughts. Ms. Murphy,
I just shared, Caitlin, with you an email, detailing what that rate, increase would look like between Lindsay and I on a community meeting. You can add that to evidence if you like.
Okay, that's not something that you've sent?
I just sent it about 5
Okay.
minutes ago.
Tom, is that something that you want to,
what is it? I couldn't hear.
it's an email, but it sounds like between Megan and Lindsay about rates.
We'll see what we get. I'm a little confused about where we are with the wastewater system and then the water system, whether we're reviewing that under 9J public utilities or 9G private.
It sounds like it should be 9G only, and because it's not technically a public
Okay.
utility.
Okay. Well, let's clarify that when we get to 9. B. Okay. That's 1B, waste management, and we'll also pick up some of that when we get to 9G. The next one on our list is 1E, streams. One of our things on our tickler list here is whether A&R has confirmed that a stream alteration permit is or isn't required.
I believe it's been confirmed it's not required. And
Do we have that from A&R yet?
I don't think we have a statement saying that. I think I haven't heard them say that it's something they're waiting on the applicant to submit. It's just a lot of times when culverts are replaced, that does require a stream alt permit. So it's, I think, just getting a confirmation from James or whoever is the appropriate person would just be helpful to have for the record.
Okay.
Who is James?
James Brady is the fishery. He's from A&R.
Christopher Down.
Pardon?
I think this is stream alterations in Christopher Down's territory.
In Crispy
Yeah,
there, yeah.
But James is our. Yeah.
And, do we need, Caitlin, do you think we need any additional testimony on culverts?
Only if you have, additional questions based on what A&R had submitted on Friday.
I did not. The next one on our list is 1G wetlands. I think we're waiting on the issuance of an individual wetland permit or maybe an amendment to an existing permit. What's the status of that?
I can speak to that. Dory Barton. The wetlands permit is still out on public notice. So there's a draft that's available, but, we're
Have
waiting.
any comments been received on that yet? Do you know?
They have not indicated that they have that.
Period 2 and 3 water supply. I think we're waiting on a general water main authorization permit. And Caitlin, what do you have on this one?
So A&R had some comments for this criterion for water supply, and it sounds like there's some conversation about that. I think hearing a little bit more would be helpful for the commission.
So we did, from starting in a year ago, December, so 2023, we did a 12-month metering study to readjust the capacity. So when we had taken, so now putting my water company hat on, when we had taken over management of the water company years ago, there were a lot of problems with the system. Just massive undetected leaks and so forth. And so there was a lot of uncertainty around what capacity was in the water system. We've, over the past several years, worked to address that, have added a well and so forth, and have since been, in good shape. And so, directed by DEC, we needed to reassess the capacity generally overall the system to understand how much remaining capacity there was. That study just wrapped up, the end of December, or actually, sorry, the end of December 2024, so just ended. And we've been going back and forth. I think these are the emails that you've seen, going back and forth to finalize the conclusion of that. We had submitted our final report, we've gotten some comments, and we're in the Q&A. And just as recently as Friday, I believe they had made, not CELA's group, so not the permitting group, but the side that works with with the water company's existing permit, had just made a final determination on capacity that was just sent to CELA on Friday. So now I think it should be, hopefully, she gets to look at it and so forth, but it should be resolved to show that we have sufficient capacity for the project, remaining for the project, and then, still a little left over.
Where does the water for this whole area come from?
It comes from wells.
Wells.
Yeah. So we have 2 4 wells.
It sounds like this could be a follow-up item for A&R to comment on.
Thank you. I think that will take us to number 4, coming right after number 3, which is soil erosion, which there are 2 parties here who have raised questions about that. So I think it would help if the applicant could make a presentation about that. And then we will take questions from Ms. Murphy.
I can take this one, Scott Homestead from Krebs Licensing Consulting Engineers. We did prepare a site-specific erosion prevention and sediment control plan for the project, submitted for, and we've submitted that for an individual construction permit to the stormwater division. It needed to be, an individual permit was required basically due to the proximity to things like wetlands, stream buffers, and steep slopes, so that triggered that. That permit has been issued, I have in front of me. So there was very few comments on our plan, and that permit was issued and was good for 5 years. One thing that I always like to point out when we have these individual permits is that can sometimes make people feel a little better, is the inspection requirements. So individual permits so all construction general permits come with inspection requirements, but typically they are performed by the contractor and or the owner themselves. An individual permit requires a third party erosion control specialist to perform and submit a report every 2 weeks. I have a project in South Burlington where I've been doing it diligently every 2 weeks for the last 8 years, and we'll be doing the same thing here. So that's, so that's comes with, a site walk, review of all implemented erosion control measures, pictures, recommendations, sort of keep a constant tally of, the amount of disturbed area, which we're trying to minimize at all times. In terms of those measures that we've implemented, they're pretty standard, typical. We're going to mark construction limits to make sure people aren't like willy-nilly driving equipment into things like riparian buffers and wetland buffers. So that'll be very important. Silt fence downslope of all construction. We're not doing phases of the project and that, one's going to be done and put to bed.
Shows some of what he's talking about.
Sure.
Yeah, so, let me go into
Yeah, this is sort of an overview.
that's the overview. Let me,
Yeah, I just did like.
Probably any of them would be good for an example.
Okay.
So the site plans don't show them there. You want to use one of the EPSC ones. So keep going down.
okay, sorry.
I would go to that 4 construction plan is probably the best one. And if you pan out a bit. So this is an example of what I started to talk about, that, we'll do this in somewhat phases. So the idea out here will be to put in the road far enough to provide access to the site so that they can get going on buildings. And that's sort of the blue line that you see around here would be the initial amount of disturbance. And we would have construction demarcation around the site. And then we would have, our erosion control measures, silt fence. We would certainly have construction entrance out onto Bolton Valley Access Road. We would have the footprint of what is a gravel wetland behind the 6plex you see on the left would be available as a temporary sedimentation pond during construction. And then all the steep slopes, we are calling for them to be matted as soon as they are installed, so that you're not going to get, a lot of bare ground out here, during rain events and those sorts of things. And so the idea would be get that in, get going, have the site basically stabilized, and then move on to the, to the areas to the north. And then implement essentially those same measures over again. And what that does is that enables this to not be, the moodscape that no one likes, where it's, a ton of acreage all exposed at once on a hillside. So.
Questions? Ms. Murphy, would you have any questions for Scott?
I don't, I think you read my commentary, so a few questions for me, please feel free, but, my main concern is I expressed when there was just history of bad behavior. And so I worry about, we've seen issues with previous projects where this aspect, I think some great that it's being, thought about well considered, but, history and fire practice demonstrated that that's sort of like a very secondary concern, which in my view is still involved. And so I just worry about the follow through, to be perfectly honest, of what's being actually described here, and that's just based on experience that I previously had with the developer. Is that 250, is that something they're gonna be checking up on as the project progresses?
Could you,
Is that something that,
could
like,
you speak up, or maybe if you're gonna,
apologies. Is that something Act 250 would be checking up on as the project progresses? Like, is that something you have the capacity to monitor? Or is it, once the permit is, goes through, it's just, we're operating on goodwill?
well, my understanding of the last testimony was that it wouldn't be active, it would be,
The stormwater management division, they review the reports and conduct site visits. Often after major rain events, they'll visit sites. There's certainly compliance from the state.
So my experience with the ANR is that they're highly understaffed, and it's very difficult for them to actually follow through on that though. I have a lot of communication about that specific issue.
if we issue a permit, it'll have that condition attached to it, and compliance with the ANR permit will be mandated under the Act 250 process, and if Act 250 if we get a report that a requirement or a condition is being violated, then we have resources to investigate and take appropriate action. We often don't hear about that, but if we do, that's what we are set up to do.
Okay, so that's very, this is sort of the same process.
We also do have reporting requirements that have been included in other permits, including some of the mountain bike trails. And I do think that there is, some of the reporting requirements haven't been submitted from what I've been able to see as available information related to stormwater. So that is just something that, like, factual, there is a requirement in that condition, and we do not have some of the reports for that, I believe.
Could I just speak to that? I think, so we got a letter just this past Friday. We
Yes.
just haven't had a chance to respond, but I believe in the permit, it's, we keep certain data, certain information, and it's available on request. I literally got it at 4:00 on Friday. Just have to respond to it.
I would just make from my standpoint, I'd love for that all to be verified before this is permitted, or the condition of the permitting, that is actually resolved. In that notification as well, I think Michaela had talked about maintenance activities that she would really like to see that have not been occurring to date, like based on visual evidence. So I just feel like that's something that should also be resolved, sort of in conjunction with permitting.
Yes, so there's several different processes. Michaela is our enforcement officer, has been in contact with Bolton and with Megan. And it's hard for the commission to review things when they're submitted, whether it's from a concerned neighbor or from our enforcement team and whatnot. So that's the point of the hearing recess order, is it will allow other comments from applicants, from concerned neighbors, so the commission can have a chance to review additional information. Because I'm not even sure that the commission has had a chance to truly go through some of the meat of, and they have not been, you haven't seen any of the information from Michaela at this point. The commission has not seen that. So.
As we said earlier, we issue a hearing recess order, which will have a list of what we're still waiting to hear from, and it is also an opportunity for other general responses. So that's going in order. We get to 8.
I think 5 was mentioned by That was Walter.
You did not ask for party status on that.
Oh, okay, I thought you had, so.
Oh, me?
Yeah?
Sorry, I did ask.
Oh, okay, I didn't get that, sorry. What, what say you about that? I think earlier when you made your party status request, you talked about construction traffic. Construction related.
In general. So,
Can you just state your name, please?
oh, Walter Duda,
Thank you.
sorry. So I'm not qualified to determine at what point the road becomes congested to the point where it diminishes the safety of people who drive up and down it. So I can only talk. As we increase the population up here, the number of commuters going down in the morning will increase. Goes without saying, but the number of commuters coming home as recreation, people who are recreating up here are going down will increase. As the business increases, the traffic will increase. The road is in terrible shape right now. It will be further degraded. This I can say with a fair amount of confidence. The heavier the vehicles that go up and down this road, the greater will be the wear and tear on the road. It may not matter that the town can't afford to maintain the road properly. That's where we live. We have only one way to get to our homes. We had the road flood and break twice this year. That kind of stuff is going to continue. I don't know how that plays into either chair, but as the building occurs, materials will be moved up and down the road with heavy equipment, and heavy equipment will be moved up and down the road on the backs of trailers. That's going to further degrade a road that's already in really rough shape. And in the long haul, 80 cars, how much does that increase congestion on a road that provides the only access to Bolton Valley? And that's the way it's going to be forever. We only have one way up and one way down. And to just sum it up again, the heavy equipment is going to further degrade the road. The road's going to increase as the business increases. It's recreational traffic. We're going to have an interplay of people going up and people going down. And on a personal note, when I drive home in the winter at 5 o'clock, 5:30 on a snowy day, I have to ask myself as I take the one path I have in, how many people driving down the road and drinking because they've been at the bar. So there's a whole bunch of things that make our commute and our safety as people who live up here pretty fragile.
The applicant like to ask any questions or respond to any of that?
No, but we did have a traffic study done, and that's, you have that.
Thank you, Mr. Duda. Mr. Duda, you mentioned criteria 8. I think you were referring to the aesthetics component of number 8. Is that right? The view or the?
Yeah, I'm at the bottom of Wentworth Road and 127, using the state's 911 addressing. So I'm at the bottom of the road and I have a deck and these buildings and the increased traffic will affect me in some way. I mean, I don't think buildings are particularly pretty because I'm a Vermonter. So yeah, the aesthetics will affect me. Even my own home is just a building, but I got a lot of trees around it in the back, So yeah,
Understood. Thank you. Ms. Gloria, do you have any comment or?
Only just to say that the buildings are relatively low profile, tucked into the woods. I can't, I don't think you could see the buildings from Mr. Duda's property or any of our properties. But I mean, want to get up there and get a line of sight, but it's pretty far away, tucked in the woods and at a much lower elevation.
Thank you. I'm sorry.
And I just have a question, curiosity.
Sure.
I haven't walked the site. I'm just wondering, are the buildings, so the road goes through where the community garden currently is, and then the buildings actually tucked back in the woods there? Is that true?
correct. Some of that aesthetics may not be an issue.
Pull the full plan.
Hmm?
You want me to pull up the full plan?
Murphy, could you repeat, I was distracted from your comment or question.
Oh, I was just curious about the placement of the buildings.
Okay.
I don't think it's actually that important.
Okay.
It's my own curiosity.
Got it. We have had some information coming to us from the wildlife program at the Agency of Natural Resources regarding the installation of bear-proof infrastructure and signage. What does the applicant have in mind for responding to those concerns?
We've been working really closely with those guys over there, so, we'll just continue to do that. I think we just have some questions about what's required. We're planning to comply with, whatever they say, but essentially the townhomes will each have their own garage. And so they'll have an enclosed, space for their trash. The condominium buildings will have shared trash and recycle areas, but we are aware of the bears. I think we've talked about gating, having it enclosed. But then, and so I think we just need to follow up with them to see, given those enclosures, what's required in terms of the actual trash cans, but that's just, I think, a conversation.
What's been the resort's experience over the last 10 or 15 years with bears?
Oh, there's definitely bear activity, yeah.
But what has?
Yeah, they spread the trash around if you don't secure it, and the resort does struggle with it, for sure. And I know a lot of private homeowners struggle with it. I myself live, just across the street from, Megan, actually, and, until I had a garage built recently and then secured in the garage. I was taking care of it, but before when it was outside, it was like they were just picnicking in my trash. So, it's definitely to be paid attention to, and we will.
Okay, well, I think my question struck a nerve. So Stephen Diglio, you have a comment?
Yeah, I've been here since 2013. At first, there really wasn't any bear activity. It was more raccoons that were a problem. They seem to have gone away. I think a mama bear figured out the trash racket and caught cubs, and it's been spreading. And the neighborhood's adapted, as best we can, but unfortunately, trash pickup happens one day a week. The bears have figured that out too. So no matter how secure you get, there's still going to be that issue of that morning when the trash comes, if you're not out there. But it's been a struggle. Neighbors have gotten like rubber shot and stuff to try to discourage bears, make it, more difficult, more less habitable. But there's a learning curve every year that we seem to forget. Like, oh yeah, they're back. But it seems like I'd say the last 5 years have been getting progressively worse.
Ms. Michelle?
Scott.
I'm sorry.
That's okay.
Sorry.
That's okay, it's a compliment. Before living at 223 Thatcher, I was living in condos up here, the village condos. And a couple of years when it became a problem, the different condo associations, like we added a door and a lock to the trash area. So it's not been a problem for the condos since we added the door and like a simple slide lock. Now I'm in a house and so now I can manage it myself, which we've been able to do successfully. But just from my experience in the condo, we added a door, slide lock, wasn't a problem.
Ms. Murphy?
Yeah, I would say, if the trash is blocked at any of these locations, like the Bears have plenty of other places to get it, really. Like they know which homes, they do a loop. There are Airbnb and VRBO sites and those tend to be an issue because like people might just put trash out and leave. It seems as though it's actually more of a neighborhood issue and I suspect it's not gonna go away because of the complications of things like what I just mentioned. They also, the bears are beautiful, like very well kept and well fed. But they're big and, they're, we have a shed, an enclosed shed for our trash, and I'm certain that they've tried to get in it, there are marks on the shed, like they sort of know the spots. And they essentially are fed by the community. So it's an issue, it's certainly an issue up here. But I think an upside for, this particular site is that if there's a lock location for this garbage, they're gonna be getting garbage elsewhere.
Have they started coming out of den already?
Yes.
I haven't seen none up there.
Maybe not up here. Yeah.
Maybe not up here.
Yeah.
They were out last night.
So given that, you have a mix of short-term rentals in your complex, to be, let's say Airbnb.
Presumably, yeah.
Then that seems to me to be more of a management issue. But if you're taking steps to provide them with a location for the trash, then it's up to the guest, for the renter to abide.
Yeah, actually, you touched on one of the questions that Claire and I were talking about we got their comment same time you did, ended last week, but one of the questions we had was what should go into the association documents in terms of regulations? What's our responsibility as the developer? So we just need clarification to finalize a plan, but yeah.
Okay.
Well, it seems like, Anna is suggesting that there are requirements for, it should be a requirement as opposed to a suggestion.
Yeah,
That's the bear issue.
right. Yeah, I just didn't know. The question we have is what goes in the association documents in terms of like, okay, each, I'm just making this up. I have no idea, but like, okay, townhome owners that have their own enclosures, given your question about Airbnb, you should have a certain type of trash can, for example, would be required. That might be an association requirement versus how we build the enclosure for the condominium. The location of the condominium trash, that would obviously be on us as the developer to build it, how they would want it built type of thing. So we just need the chance to have a conversation with them to follow up on this.
Sorry. Yes.
This is Kim Schmidt. I just had a question on the mandatory composting and how does that play a role in all of this? And is there a way to do compost pickup? I know some people in other places have done that or block the compost or how to do that because that also helps with the sewage if you're not putting all that stuff down in the garbage disposal.
Take note.
One more question.
I was just gonna add the comment that when I was living in the village condos, that was part of the trash area where we were required to put in compost and it was part of the arrangement with the garbage company. And so we, as a condo, were required to do that and the service picked it up.
Maybe we combine garbage and compost.
I think we can move on to 9A, impact of growth. And ask the applicant if they have anything to offer or comments to make. under that one.
Impact of road. See if they have something.
Or if you wish, you could respond to the comments and questions that come from Ms. Duda and Ms. Murphy.
I could, either way, they can go first and then that way I don't have to go twice.
It's only Ms. Murphy and I. Okay, Megan, you are at the floor now on the impact of road 9A.
I think my main comments were related to,
Can you?
like, oh, I apologize,
Sorry,
sorry, I have a soft voice. I think my main comments were like related to, concerns about failing roadways, or we already have like severe issues with the road, and I don't believe that there's funding in the budget at any time in the near term to address those, and I think the report that I share with you all, which is incredibly long, and I'm sorry, highlights many of those, and that's from 16 years ago. I don't believe that any of those updates like discussed in there have been addressed to date, and I don't see, I mean, Leah may be able to speak to this because she's on the board, but I don't believe there's the budget for roads at this point. We're just trying to catch up on costs related to flooding. So that's my major concern.
Any response?
You want me to go now?
For clarifying.
Yeah, I was just gonna add, the road will be privately owned, so it's not the responsibility of the municipality to cover the cost of the maintenance of the private road. We did ask the town to fill out the municipal impact questionnaire. They recognized that it would be a private road and they didn't identify there being any concerns about, maintenance of the access road in relation to the impacts of this project.
And then I guess, I would just say, I know I said this, of course, I don't want to be repetitive, but it's consistent with the town plan, with the master planning that was done for the resort village, with the regional plan, CCRPC also. I think you have a letter to that effect. We did conduct the traffic study, have the utility capacity, the school district, part of the questionnaire, talks to make sure that the school district has capacity. And then everything I sort of mentioned about the process. Attend to that.
Did you have anything for that? I got it on 9A yourself.
I did not.
You did not, okay. Okay, I can do this. Mr. Diglio.
Thank you, Dennis. I just wanted to say, this is a town road. When it comes to this being built and constructed, the cars aren't really going to impact the road. When we design roads, we don't look at cars, we look at trucks. And if anything, it's the town plow that's causing a lot of the damage, the snow plow, the snow maintenance, salting. It's causing a lot of issues, and having more tax base will help the town actually have more of a budget that will help us hopefully fund our roads. That would be, my comment on that.
Okay. Ms. Murphy.
I don't want to minimize the town plan, but I think it's important to note that Lindsay's brother Evan was part of that process. So I think the town had like their own, I think the resort had sort of like a lot of influence and maybe what went into that. Not to say, I don't necessarily know that there was a conflict of interest, but I know that, I think that they had a lot of buy-in and what went into the town plan. I just think it's worth noting.
I can add to that. We were actively engaged with the whole community effort around engagement. The resort, of course, would engage in the process, wants to engage in the process. And we're active participant in particularly when they did the master planning up here. We were active participants in that process. Of course, that was our first year here, so we were still getting to know the place ourselves. I mean, not that we didn't know it from before, but a 20-year hiatus is long, so. But yes, we actively participated.
Thank you. It goes to 9G, private utilities, and we pick up the the narrative of earlier on concerning the water, the private water supply system that functions for the, what we, I guess we'll call the community of Bolton Valley. Murphy, why don't you re-articulate those concerns if you would?
So I think to put it really simply, like a concern that we, being my husband and I have had since our conception, been that in some way the community is voting to developer this through the utility. And that's an ongoing concern, I will say. I mean, there was a lot of, I mean, I think this project has sort of been in the works since the Delorean family, you know, purchased the resort back. There have been many improvements made to the water lines and leaks, et cetera. I think, you know, were necessary for the community. Some of them seem, you know, from our perspective, timed and of interest to future development also. So, I mean, it's a constant question for us as to what are we putting the bill for? It's like, we have very expensive drinking water. It's among the highest rates in the state, drinking and sewage, I should say. And I think the proposal that goes along with this for the community, and I documented this in the email that I sent to you, results in like a 60% rate increase for 3-bedroom, which is kind of standard size, over that 10-year period. What Lindsay was describing as not being very much is actually a lot. That's a lot of money. It's cost prohibitive for people. And I think this is, you know, I'm not saying this is something to be taken up with you. This is the PUC in a sense, but there's this funny, like, you know, integration between they own the resort and they own the utility. That means that nobody else wants the utility. It's a huge headache. You know, it's all failing infrastructure. It's old and it wasn't maybe built as well as it could have in the first place. I think it dates back to the 60s. It's always been expensive. This has always been, I think, an issue up here. But you know, I have concerns that we are again somehow going to be putting the bill for something that's not actually helping us, right? Like we're not gaining revenue from the development. That's just BBR and investors. And so that's a hard pill to swallow for a community member. And it was pitched to the community as, and I noticed the email between Lindsay and I, and she didn't respond saying, no, I didn't say that. It was pitched as, oh, it's only going to be $8 for the $8 increase for the first quarter. And there was no information shared about what that cost increase would look like. So I am also concerned about, and I realize this may not be what it shakes out to be. In fact, it may be more expensive, just given what the rising costs are going to be of construction near term, I believe. But in my view, it was not a transparent description of what likely was to come down the pike for us. And again, I mean, this is something to be taken up with the PUC, I think, ultimately, but there's this funny interworking between the two entities because they're almost essentially about the same. I think it doesn't give community members necessarily a good feel, especially those that have lived here for a long time. And like I said, particularly cost prohibitive for people in the condos already. I've heard so many stories of people saying, I want to move up here. And then they find out the cost of the water and they're like, no, can't do this. Like the cost of water is going to be more than the cost of my mortgage. That may not be true anymore, but it used to be.
Okay. Mr. Duda.
Oh, and sir, you may call me Walter, if you'd like. Yeah, and I also just wanted to add, as I said earlier, the water is not metered here. I don't know the algorithm that describes water costs for the businesses up here that are owned by the corporation, but I do know that the water is not metered, so people pay based on whether they have a bedroom in the house or not. My wife and I, we don't have any kids. We bought when the ski area was closed, got a pretty big house. It's nice, I feel grateful. But our water use for sure would not equal the water use of a family. I don't know, how, businesses use water, because I've never had a water intensive business. But, I just want you to understand how the prices are structured here. We actually won the fight, so we have the pellet stove in our house can't be a bedroom by definition. Reduced our bedroom size by 1 when we put in that pellet stove. But there was always only been 2 people in that house. And that's why the utility is prohibitively expensive. If a family comes up here and they have a bedroom for the couple, a bedroom for the kid, and a 3rd bedroom that they're using as an office, they got 3 people using water, but they got 4 bedrooms, and they're paying water as if they had 4 people living in there full time with the taps on constantly, I guess, because our water is incredibly expensive.
Thank you. Ms. Deloria, do you want to reply or respond to any of that?
I mean, I can, I don't know what's relevant and not relevant to you. I mean, with the water rates, the way that you have to bill as a utility is you have to be prepared to provide maximum service. So you may have one person living in your house in a 5-bedroom house, but unfortunately your bill has to be for a 5-bedroom home because the water utility has to be prepared to provide you with that service. And in fact, has to be prepared to provide the community with its full occupancy, and that's how our allocations are determined. I don't have the exact numbers in my head, but the allocation for commercial use, we do have meters on the commercial buildings. We don't have them on the residential. The residential is totally based on bedrooms. The water allocation that we just went through the process to determine is significantly less water allocated for the commercial, but the commercial pays about half of the bill. So definitely pays a fair share. We inherited those rates. We didn't change them when we took over. The PUC regulates the drinking water side, so we don't even have the ability to determine those rates. They are right. Our rates are really expensive. It's a real concern for this community, as it is for a lot of small communities, where you just don't have a rate base to support the service, and particularly, with the aging infrastructure. When we got here, the water company was actually at the point of failure. Like I mentioned before, I appreciate, Megan acknowledging the work that we've done. It has been an effort. Nobody else does want to do it. That's all true. And we continue to have to do it like this required upgrade, $8 million, huge burden on this town. And I certainly did not say the increase was small. I said, I believe at that meeting I made an example that the first increase would be $8 a quarter. But like I said to you, we're looking at annual increases over about a 10-year span of either 3 or 5% per year. That adds up and is not small. It's a big part of the reason why we think this project is so important for the community. We've sought countless grants to try to, mitigate the impact of that on the community. I myself am a community member and subject to the same rate. So absolutely, but I don't think any of that is really relevant to this project. But I just want to sort of address those concerns. Megan did say one thing about timed improvements, feeling like the community is footing the bill. I just would strenuously object that. I don't know if this is the place, but in order to respond to it, I have to know what she's I don't even know, what improvements she's talking about that seem to be advantageous for this development, as there have been no improvements connected to this development at all. So don't know how to respond to that.
Ms. Murphy, yes.
Yeah, I mean, I guess I have a question that comes from this, which I didn't think to ask before. And the question is would the sewage treatment plant upgrade even be possible if this doesn't get permitted? And how would that look? I mean, that's really the basis of where I'm coming from on this. Or would you be considering other options at that point? Would you be considering, okay, how can we upgrade this at a lower cost? Or how can we just fix the problem without upgrading fully? And that's sort of what I'm getting at. I feel like it hinges on this project, and that's concerning to me.
it doesn't, unfortunately, I mean, it doesn't, I can just respond, it does not hinge on this project, it's required. We have to do it. This project will alleviate some of the burden of it on the community, for sure. But there is no connection between this project and the need to upgrade that. Our existing facility, like I mentioned, has zero redundancy. It has a single, treatment, whatever. The new one will have redundancy, will, meet modern standards. And the old one is in disrepair. I think in Megan's, in one of the things that she's submitted, she noted that it's in disrepair and that we've been operating it and sort of eking it along in disrepair. But then the conclusion that therefore we could continue to do that indefinitely, I think that our regulators would disagree with that conclusion, as would we. I think the risk is catastrophic failure at a high elevation in the watershed with no redundancy. And so there's a sense of great urgency to get this done. It's been a process, a multi-year process of going through design. The design is very expensive. We're down the road. We're just in the final stages of getting permitting, planning to break ground now in 2026. We did delay it for 1 year to try to get this big grant that would allocate a couple $1 million for the project. We're hoping to secure that. I mean, sorry, I know I'm off topic. I'll stop.
So I'm still with that question, like, what would be the solution if it goes up?
Higher rate than the 5% annual.
I mean, higher rates to the point where like, what, we wouldn't be able to live in the community. I just feel like, no, I mean, I'm serious, like.
I am
what
also.
would- And were those explored, like, did you consider the cost of like making a repair to the, I totally understand.
We did,
like,
we had a full
improvement to be
needs for
more
the
sense, but,
This is
You know-
also a different project.
Yeah.
So just want to
yeah,
make sure.
well,
everything-
and the reason I bring it up is because to me, they're quite intertwined. And from a grants perspective, it sounds like they are, and the financial perspective.
I'm not the applicant on that. I just want to say, mostly also for the record, what you are discussing is a different permit amendment, just for the record for folks that may be requesting back on this.
I think that takes us to 10. Criterion 10, which is the local and regional plans. And Megan Murphy, I believe you are in on that one as a party status. Could you re-articulate that concern?
Sure. Yeah, that was related to, I don't have all the information, but full disclosure here. That was related to, I think it was last week or the week before, Claire had come to the select board and asked, she essentially pitched to the board like, hey, Act 181, like regional planning, it's gonna come to the town in the spring and, ask you to approve their map, or like how things are classified. And her pitch essentially was like, Bolton Valley is likely gonna be classified as it's like a recreational, region. I'm not getting the wording right, I'm sure, as a rec area. And she was asking that they upgrade it to a village area, which essentially affords them Act 181, exemption. My concern in that moment was like, wow, like nobody on the select board actually knows anything about Act 181. It's getting pitched to them. I'm really worried that this is, potentially has something to do with this project and essentially would allow like more development in an area where we're already having like so many water issues. And generally speaking, my concern is like pretty sweeping, like development at the top of a mountain, that already has water issues concerns me because we're constantly running the risk of like losing our roads and flooding events becoming more and more frequent. And I think the report that I shared kind of details that from 16 years ago, like the more development that happens in this upper watershed region, the more issues we're gonna have downstream. We talked about that in detail in the report. I feel like we've been seeing those impacts already. Between that time and now, there has been more development and we've seen more issues. And so those are the things that I'm thinking about, with respect to Act 181 piece, like my concern was that I really don't think this is a region. And again, this isn't exactly specific to this proposal, but I was worried that it might be linked in with it. In my view, it's not suited to that. I don't think that was the intention of that action. And so that just raised concerns for me about the intention of the developer.
Does the applicant want to say anything about that?
Act one, obviously that wouldn't relate to this because we're in an Act 250 hearing. And I think the process for 181 is for the town to advocate to the CCRPC. And so we're just engaging in the process as laid out, I think. But it has no connection to this.
I think the connection is that you'd be skipping Act 250 hearing in the future should that designation be made, and that's concerning to me. And I believe it's retroactive, so like you get that designation, you can apply it to this project. And I believe so that is how it fits in for my practice.
Okay, that I think concludes the testimony of Mr. Duda.
Oh, thank you. I just, I wanted someone to clarify, what Megan said, sounded really important to me. And I'm wondering if the applicant would deny that that's true, or, if there's someone here who knows, could say if that's true. The idea of bypassing 250 up here is about as scary a thing as I can imagine.
Well, that's sort of in the workings out of however the WAC 181 changes manifest themselves, which we're, I think, a couple of years away from. I would pay attention to it. Best thing you can do.
And it does involve, starts as a local process, and so it's certainly outside of any commission decision, but Act 181, I would look into it. It does change how Act 250. Act 250 jurisdiction applies just broadly for a densely populated area or untouched wilderness, so.
I would just say with or without Act 250, I don't think this project would change.
That's
with all the environmental restrictions and permits that are still going to be required, I still think this proposal would be the same. So I don't know if that would
The piece
change
that
anything.
might be important though is Act 250 has oversight and compliance oversight in particular, as noted, which I'm not sure about for this case.
I think I am a little hesitant to get down this just because this is all very preliminary and there's a lot of things that would need to happen before there's jurisdiction changes that apply here. There's not going to be, it's not going to apply retroactively. If a jurisdiction was to change, what is created in permits now would still apply later. It might just depend on who is enforcing it, but it would not change this permit going through this process or the purpose of this hearing right now.
Would it allow for expansion of the project?
There's no way for us to know that right now. It's a whole wild world depending on what tier it was determined to be, which is again, a totally separate process outside of the commission. And as I always do, I would recommend it's being involved with your local processes anyway.
I have one final question. Part of this project is called the picnic loop. And I saw a picnic table out there. What's the short story behind a picnic loop?
The picnic loop name is a great example of lazy naming. The picnic loop is the name of the cross-country trail that runs in that area. The actual development when we go to, market it will not be called a picnic loop. But, for the sake of not having to be creative, we just named it after the cross-country trail that's right there.
Well, it's not necessarily a bad name. Okay.
The result of having no formal land planner, leaving it to the engineer.
So, what we do now is, we thank you for your participation. We will reflect on all of the testimony and the other evidence presented today. We will issue a hearing recess order, which keeps the record open until the deadline in the hearing recess order, in which we ask the applicant and sometimes other parties to submit supplemental information. You heard earlier on, we were asking about some stuff coming out of A&R. We've asked for maybe sometimes more formal responses to questions that were asked today, and we allow the other parties to respond to those supplemental filings. Once all of that is complete, we consider the record to be final and then deliberate and issue our decision as soon as we think we can issue an informed decision based on the evidence and the law. And we probably will get the hearing recess order out by the end of this week. And if you've given us good contact information and we can read your handwriting, then we will send that to you, your party. So that concludes our work here this morning, and we will stand in recess. Thank you.
Thank you.
Thank you, Mr. Burrow.